The next question, number 7.
Thanks, Concorla. Minister, this refers to a clause of the Defence Forces Act and subsequent regulations which were actually overturned and amended 30 years ago, whereby the President of Ireland could forcibly retire somebody without that person having any rights to a hearing, a court-martial, or even knowing the circumstances against them. So in light of the fact that you have furnished me with information that in the entire history of the Defence Forces only 2 individuals were ever dismissed under this clause, and given that it's now been amended 30 years ago, would you revisit on an independent basis those cases in order to achieve justice for the people at the heart of them?
Thank you. Minister, number 7.
Yeah, just, if you could bear with me, it's quite a complex answer, so I just want to put it on the record, if that's okay. At the outset, I'd first like to correct the record of the House. As the Deputy will be aware, the military authorities previously advised me that 12 officers were retired from the Defence Forces between 1954 and 1985 under the provisions of Section 47(2) of the Defence Act 1954, as prescribed by Defence Force Regulation A15, paragraph 18(1). This was communicated to the Deputy in response to PQ 47503/14, which was for written answer on the 11th of December 2014. This response reflected that 2 of these officers were recorded on file as having been retired, in brackets, in the interests of the service. I'm now informed that further investigation has shown that while these officers were in fact retired under the provisions of the Defence Force Regulations A15, they were not retired in the interests of the service. The officers in question were retired under a different provision of the regulation for failing during the course of training to maintain satisfactory progress. I have been advised by the military authorities that these 2 cases date back to the 1950s and involved 2 officers who failed essentially flying tests and were unsuitable for transfer to other barracks of the Army on age grounds. This being the case, I can see no necessity in initiating an independent inquiry into those cases. I can therefore advise the Deputy, based on the information now provided by the military authorities, that only 1 person has been identified as being retired in the interests of the service, as per Defence Forces Regulation A15, paragraph 18(1). This case was subject to a resolution adopted by Shannon Aaron on the 10th of March 2010. The Shannon resolution included a provision that the Government would ask the Judge Advocate General to select a nominee to carry out a review of the documentation on file to determine whether, on the basis of the documentation and information available to the Defence Forces at the time, the decision to compulsorily retire the officer was a reasonable one. The individual in question was also offered the opportunity to make written submissions to the reviewer based on the relevant documentation. The Government remains willing to carry out this review within the terms of reference of the Shannon resolution and subject to the person's agreement and cooperation.
Thank you, Minister.
Finally, I'd like to clarify for the Deputy that none of the clauses of paragraph 18(1) of the Defence Force Regulation A15 were removed in 1985. An amendment was added to the regulation in 1985 to require that the reasons for a proposed retirement in the interests of the service be communicated to an officer and that he or she be given a reasonable opportunity to make representations.
Thank you. Deputy Clare Daly. I'm sorry. We're over time. Sorry, Deputy, we're over time. Deputy Daly.
I don't mind. I was trying to hear.
That's all very well, but Deputy Wallace and Deputy Murphy have questions as well, you know. So, I mean, I'm against the clock here. It's not my fault.
That's fine.
Yeah, okay. Well, look, I mean, it is difficult when there's extra time taken, and there was a huge amount of detail in the Minister's reply there. But, I mean, the bottom line in terms of this regulation is nobody now could be dismissed from the Army on the basis that this one individual, that we now know one individual was, to spend a lifetime dealing with the shame, if you like, of being dismissed, not knowing the reasons why, not being given a right to have your good name vindicated, not being given any evidence against you, a right to attend a court-martial or whatever. And, you know, I'm a little bit thrown, if you like, by the correcting of the error of the Dáil record yet again. I find that a bit surprising. Would it have been corrected if I hadn't done this subsequent question? I'm kind of reminded of the fact that when this individual did go before the courts, a document which was of key strategic importance to his case, was missing for 32 years and failed to be presented to the Supreme Court, which showed that the man, before he was forcibly retired, had made legal representation through his solicitors to the Defence Forces and got no reply. So this is a 70-year-old man who spent his life seeking justice for a decision that was made, that we now know he's the only person in the history of the state to be dismissed in this way. 45 years he's carried this, and I am really urging, I'm not clear on the resolution that you referred to because there was a lot of detail in your answer, but are you now saying that you will give some opening to a new independent evaluation of this, given that the High Court is on record as saying that he didn't get fair procedures and as he is ageing in years? So.
Minister.
Yeah, well, first of all, just to correct the record on something that you just said, it is possible that somebody could be forcibly retired from the Defence Forces under this article now, but it would be only likely to happen in very exceptional circumstances. Right? Yes, they do. Yes, they do. Yes, they do. Right. I've spoken to you about this outside of this chamber, and I said that I'm anxious to be helpful here, and I am anxious to be helpful. But I am somewhat constrained in terms of what I can say and commit to on the record here, in terms of what I can legally do. But I am anxious that we would treat this case with fairness, and that any review of this case that is possible would, one, be consistent with what the Seanad had been calling for a number of years ago, and obviously, even more importantly, that review would be something that the individual himself would welcome and accept as fair. And so I intend on writing to him to outline what's possible at this stage, and I hope we'll be able to make progress on it.
Thank you. Deputy Daly.
Well, I'd just like to thank the Minister for that, and to maybe, sort of re-emphasise the point. If we're going to do this now again, and finally, properly, after all this time, well then, hopefully it is in the spirit of getting a fair result, and I'm very grateful that you have indicated that you're willing to do that, and hopefully it can have a resolution. Yeah.
Thank you. Okay.
Just say, it's important not to predetermine an outcome. I mean, there are two sides to this story, and that is why I think any process that would be proceeded with now is one that's fair and involves a full assessment of the case, in as much as that's possible, because this happened quite a long time ago. But as I say, I intend on writing to the individual concerned and outlining what I deem as a fair way forward that is consistent with everything I've outlined, and hopefully we'll be able to progress on that basis.